I'd like to welcome Renee Coover, who's a partner at Bird Adato in Chicago, Illinois. She's going to talk on personnel issues. One useful piece of information here is there is a blog that Renee and her colleagues publish on their website. So you may want to check that out just as another resource for you that's mentioned tonight. Renee,
Thank you,
welcome.
Dr. Jewell. If you want to advance to that next slide, that would be wonderful.
You're really going to want to listen to this.
So thank you for having me. I know we are in uncharted territory right now, and not only for us as attorneys, but all of our clients and a lot of businesses as well. So we are seeing changes on a daily basis, really due to all of the legislation that has been fast-paced and some of the amendments that are being made to the legislation as soon as it comes out. So over the past week, the employment issues and the answers that I have been addressing have changed really from before we're talking about telecommuting policies in depth, and now we're talking about office closures, unfortunately. So I have been dealing with quite a few questions from our clients, which are particularly small businesses, medical facilities, medical spas, and the majority of the questions that I get really do evolve or revolve around what do we do with our employees when it comes to an office closure, or how are we going to reduce our staff? And so the first category, I guess I would say, that I get these questions in is having too many employees during this time, right? Where you have been either forced to close or you are trying to reduce staff and you have too many people on. And this leads to a lot of issues for reductions in both pay and hours. I will get to kind of the specifics of that on the next slide, but one way to deal with too many employees during a pandemic like we're in a crisis is coming up with some creative solutions. So telecommuting being one solution that a lot of our clients are using. And I know we're in a healthcare industry where telecommuting is not always possible for your staff who is in office every day dealing with patients. So looking to telehealth as another platform to actually consult with your patients during this time is another option before having to actually reduce pay or reduce employees' hours. And then if you have gone through that exercise of reducing pay and hours, there are always temporary furloughs, and I will address that in a moment as well. But when it comes to temporary furloughs, really the difference between that and a layoff is that you are telling employees this is of a temporary nature. So for the time being, we have to close our office. It's been ordered by the state or by the government on a local basis, and we are letting everyone go on a very temporary basis. Typically during that time, employees are going to be able to keep their benefits, but they also can apply for unemployment benefits as well. So it's a way to avoid having to fire and then rehire employees if you go through a furlough. Finally, we have permanent layoffs, which of course no one wants to have to do, but we are in that stage with a lot of our clients who are looking to come up with a more skeletal staff and really look at the essential employees that they need to have on and who unfortunately may be a more expendable employee. And sometimes looking at seniority is one way to handle this. On the flip side, we're seeing issues with too few employees where you have especially in the medical and healthcare setting, employees who are unwilling to come to work or unable because either they're experiencing the symptoms of this virus themselves, or they are caring for others who are experiencing it, or they have childcare issues which are prohibiting them from coming to work. So this is really another time to think about your critical staff, your critical positions within your company, and start to come up with a business plan for both the short term and the long term in order to reduce the amount of employees that you have in the office. If you could move to the next slide, Dr. Jewell, that'd be great. So when I talked briefly about reducing pay or reducing hours, one question that I have gotten over and over this week from plenty of different of clients of ours is, what do we do if we do need to cut someone's hours or we do need to reduce their pay? And before we can dive into those issues on an individual client basis, we have to ask certain questions. The first question being is that employee exempt under the Fair Labor Standards Act, or are they non-exempt? And these are two categories that have been created by FLSA. Exempt meaning the employee is under the exempt test, they are a salary-based employee, and they fall into an FLSA exemption. There's several exemptions, the main ones being administrative, executive positions, or learned professional positions. So these are employees that are on a salary basis, and they are not subject to any overtime or minimum wage requirements. On the flip side of that, we have non-exempt employees who, these are your hourly, typically your hourly overtime employees. So if they make, if these employees are on a non-exempt basis, it will make a difference in the classification. If they make less than 23,000, I think it's 23,600 a year, they are going to be classified as non-exempt because that is your salary test. So I just had a call with a client today who wanted to take several of her exempt salary-based nurses and just shift them over to a non-exempt hourly model in order to reduce their salary and reduce their hours. And you have to be very careful when making those types of decisions, because they can have long-lasting effects, both from a financial perspective, an employee classification perspective, and a tax perspective. So you want to make these determinations on an individual basis, depending on that employee's status. And if you are trying to reduce an exempt employee's wages or hours, that can actually affect their status as an exempt employee. If that employee's hours, or I'm sorry, pay is reduced below that salary basis of 23,600, they would then shift into a non-exempt employee. And there's different qualifications and obligations for that type of position. So you want to be very mindful, both from a federal perspective, but then also from a state perspective as well. When it comes to PTO, sick leave, and vacation, and we get a lot of questions in this regard lately because there's so many questions that are being posed as to whether the employee has PTO, and if they do have it, do they have to use it, or can they be forced to use it? Or, if that employee comes to the employer and says, I don't feel like I should have to use my PTO, what do you do? So these are all, again, individual type analyses that we have to do. And you want to be very mindful of any state-based paid sick leave laws that could affect this analysis. So, for instance, I'm in Illinois, where we, on a county basis, do have certain paid sick leave laws that require the employer to give a certain amount of paid sick time to their employees. If you have these laws in place, this could affect your analysis as to whether you need to give that sick leave to the employee during this crisis, or if they have vacation or PTO time. Something else to be cognizant of is that as an employer, you have the option, if you have the financial ability, to advance PTO or sick time to your employees. So if you're looking for a way to take care of them during this time and you're not sure whether they have the PTO available or they just don't have it available, it's always an option to advance them that time. You could move on to the next slide, Dr. Jewell. Thank you. So this always brings us to the other tricky issues regarding employee benefits and leave issues. And we're going to dovetail into the paid family leave and the Families First Act in just a moment. But looking at situations where you are closing your office, or you have to furlough your employees or lay them off all of these benefits issues and leave issues come to light for sure. So when you're looking at employee benefits like health insurance or retirement, some things to keep in mind from a global perspective, and I mentioned this in the beginning, is that if you're doing a furlough, this is of a temporary nature. So typically, and you'll always want to check with your particular health insurance carrier, but typically the employees can continue their health insurance during this furlough time. And that's different than a layoff, where if you are going to lay off an employee, that's a much more permanent nature. And so in those situations, typically the insurance is going to end at a certain period, probably the end of the month in which that employee works. And then after that, they need to apply for COBRA. But if you're doing a temporary furlough, the insurance typically will continue. Another thing you can think about during this time, if you do have to close or you are cutting back on staff, is consider pausing your discretionary retirement plan contributions. This is something you would definitely want to communicate to the employees if you make this decision, so they know this is happening. But it's one way to save some money and potentially not have to cut back the salary if you can pull back on other areas. One area that I'll just briefly touch on before we jump into the Families First Act is under traditional FMLA and ADA. So here we're talking about the Family Medical Leave Act and the Americans with Disabilities Act. Typically, if you're an employer with 50 or more employees and an employee has a serious health condition, they're eligible for FMLA. There's usually other requirements. That employee has to have worked for the employer for at least 12 months and a certain amount of time. It's 1,250 hours. So there are lots of conditions that have to be met if an employee is going to apply for their 12 weeks of either unpaid or paid leave under FMLA. The same goes for an employee who may have a disability under the Americans with Disabilities Act. If that employee can prove that the disability affects a major life activity, they may qualify for the Americans with Disabilities Act. This is going to come into play now, as we'll see in a moment, for the coronavirus, because the requirements have been relaxed by the federal government when it comes to proving either a disability or proving that you are eligible for leave under the Family Medical Leave Act. If you could go to that next slide, Dr. Jewell, that would be great. So that brings me to what I think we're probably all becoming more and more familiar with, which is the Families First Coronavirus Response Act. This passed in the beginning of last week after I think it signed or was passed Trump's desk on Monday of last week. And so this act is there's already amendments being discussed. And so we have not actually seen the act effective yet. So it passed and now it will become effective on April 2nd. And so, and hopefully there will be no amendments before that. But this act really was intended to give employers additional benefits for their employees during this crisis. And so what we're seeing are really three different categories of benefits. And the act itself has completely expanded the definition of both a covered employer and an eligible employee when it comes to paid family leave under the Family Medical Leave Act. So typically, as we talked about, there are strict definitions for a covered employer, someone who has an employer that has more than 50 employees. And then to be an eligible employee, historically, you would need to have worked for that employer for 12 months and for a set amount of hours and have a qualifying serious health condition. So with this expansion of paid family leave, all of that is out the window. Now a covered employer is any employer with 500 or less employees. And we'll get to the exemptions to that in just a moment. But to be an eligible employee, there is a whole list of qualifying factors, none of which requires that you've worked for that employer for a certain amount of time. So you can qualify for this paid family leave if you have been infected by the virus, if you are taking care of an individual who's been infected, if you're exhibiting symptoms of it, if you have a child at home that has experienced a closed school or closed daycare. And then if your business was ordered to be quarantined or closed due to any state or local ordinance, that's another reason an employee may qualify. The flip side of this Families First Act is the other part of this, which is the emergency paid sick leave. That sick leave, again, has qualifying factors, but it offers up to 80 hours or 10 days of paid sick leave for qualifying employees under this act. And because there is a waiting period for the emergency paid family leave of 10 days, this sick leave in some ways fills that gap. So potentially an employee could get 10 days of paid sick leave, and then also qualify for up to 12 weeks of paid family leave after that. So there are two types of leave available under this act, as well as an expanded unemployment insurance for employers. Two exemptions that are important under this act are, one, there are exclusions for employers that have less than 50 employees. So similar to the traditional FMLA, if you have less than 50 employees, as an employer, you can prove that the compliance with the act would jeopardize the viability of your business, then you do not have to comply with this act. There are also exclusions for healthcare providers, and this is an area that we're hoping there's going to be further guidance on once the rules and regulations are hammered out later this week. But looking at the traditional definition of a healthcare provider, it's very broad. I believe the government probably intended it to be broad because they want healthcare providers going into work and helping fill the gap during this time, since there are shortages. So I think it will be very difficult potentially for healthcare providers to be eligible for either the paid sick leave or the paid family leave under this act. A lot of people have asked, well, who is paying for this and how? And so really, right now, as it stands, this act, the leave that is being provided under this act is being paid by employers and then coming back in the form of a tax credit. And how that is being worked out is also an unknown. There are a lot of nuances to this act. The IRS is being tasked to come up with processes and forms, and it's an ongoing process that hopefully will get some more clarity later this week. So, and finally, I want to touch on, and I know I rushed through that and I apologize. I could probably do 2 hours on the Families First Response Act because there is a lot going on with it. But I will say it's all very fluid at this time, and we don't have answers to all of the questions. There are still a lot of unknowns until these regulations are put in place. So finally, I want to touch on, if you could go to the next slide, Dr. Jewell, the small business relief. This is, again, another type of relief that is still fluid. It has not passed yet. I know that Senator Marco Rubio was championing this bill over the weekend, and there has been a back and forth. I believe there was supposed to be a vote earlier today, and I was unable to get any results from my searches for that. But ultimately, this small business relief bill would help employees or employers by providing $300 billion in relief for small businesses through this federal relief package. If it does pass in the current form, then small businesses with less than 500 employees would have immediate access to cash flow through these 100% federally guaranteed loans. And the hopeful aspect of this, I guess, is that if it passes in its current form, if an employer maintains their payroll through June 30th of this year, instead of laying off or furloughing employees, it would potentially be possible under the current form of this that any federally guaranteed loan that employer took out to help with cash flow would be 100% forgiven. So it would basically be a federal grant. So the next question becomes, well, what if an employer has already laid off staff or furloughed people? And in, again, the current form of this federal relief package, these employers would still be eligible for loan assistance if they rehire employees that they lost as of March 1st. And there is a date for that rehire. I want to say it's in May, and I don't have the date in front of me, but we're hoping that this federal relief package or something similar does go into effect, because I realize there are a lot of small businesses that are trying very hard to keep their staff on and not have to furlough employees or lay them off. And hopefully with some type of relief package at play, this would be a more viable option for small businesses. So thank you.
Thank you, Renee.
For your time. Yes.
Renee, tremendous amount of information, and some of it we actually understood. Is there any possible way that you could bullet point a number of these things and then have the Aesthetic Society distribute that to their members to clarify this? Because it really is down in the weeds, and we're all facing these things. One of the questions, and by the way, that bill did not pass today. Hopefully it'll pass later today or tomorrow. The issues are amendments. You mentioned exempt, non-exempt. Can you take an exempt employee, say we want to change you to a non-exempt, cut down your hours, say, or your salary by 50% for a period of time with the idea that you want to keep them, and then go back to an exempt later?
That's a great question. The issue with doing that from a legal perspective is that when you are transitioning an exempt employee to non-exempt, you have to have what they call a defensible reason to do that. And typically that defensible reason is kind of threefold. One, that it's being done on a permanent basis. Permanent in the sense that it should be at least a 3-month permanency. So it's not as permanent as it sounds probably, but you would not want to flip someone from exempt to non-exempt and then 30 days later make them exempt again. So that's one consideration. Two is you want to be careful not to tie any salary reduction to a reduction in hours, because that can change that person's status, and it may again have implications from a tax perspective, as well as an employment tax perspective, as well as their exempt status. It's best if you're going to change an employee's status that you do it across the board for a class of employees and not cherry pick out employees to do this for. And we just had a conversation with a client earlier today who wanted to take multiple employees and change their status from exempt to non-exempt. And we had to really work through analysis of what these employees did, whether they could change their status, and what effect that would have. So it is an individual analysis, but I would say there are implications that can result from the way you do this, how you implement.
On the other hand, there are a lot of offices that are going to be faced with the options of either doing that or just telling the person that we have to terminate your employment. So will that have any effect in getting additional funding from government moving forward? Or is that still up in the air?
I think that's still yet to be seen. There's a lot of moving pieces that we don't have answers for at this point.
Well, we could take another 4 hours to go through this, but Mark, I think we should.
I got a question for Renee. You know,
Sure.
with hourly employees, talk about job sharing, where, you know, 2 people would occupy one job in some capacity. maintain their benefits otherwise. How viable is this?
I think that's a great idea. It really is going to depend somewhat upon your business structure and and the employee's willingness to do a job share program. It does sort of change their role in some ways and can change, again, their status or their benefits. So that would be a question, if you're taking an employee who is traditionally full-time and reducing them to a part-time schedule, it could have an effect on their benefits eligibility. So that would be a question to talk with your HR representative or your benefits administrator to make sure that if they are going to work share and they're willing to do that type of model, that it's also viable for your business.
Yeah, we were able to do that during the 2008 downturn, and it seemed to work very effectively for us.
Yeah, I actually spoke with a client earlier today who was hoping to implement that for 2 employees who had the same job. One employee was very hesitant to come into the office at all, and they were going to work out a job share where they could both telecommute, and it would be a split day for each employee. So it can work, and you just want to be mindful of those benefit considerations.
Good.
I think it's also important if you're going to be doing that. I think that most of us who've closed our office, and I did electively last week, to let employees know you're not taking a salary.
Yes, definitely.
Yeah, and if I can, gentlemen, if I can ask Renee one clarifying question. In the event that the office elects to have a forced reduction in hours for a non-exempt employee, is it correct that the current federal unemployment benefits can provide some amount of supplement for that employee if they qualify and apply for a reduction in their employment, even though they are not fully unemployed?
Yes, it will depend on that benefits provider, but they can still potentially get benefits, yeah. And that's something, I forget actually at this point if I actually addressed it or not, but when you have and this probably will be popping up as a question, but for non-exempt employees, if they are not working, you do not have to pay them. That's not an obligation. But if you have an employee who is exempt and they work any period of a week, so out of a 7-day week, if that exempt employee works for 1 hour, they are guaranteed their salary for that week. So it's something to consider when you are thinking of reducing hours or reducing salary, because for a non-exempt employee, there aren't the same issues. But for an exempt employee, if they're not working at all, there's no obligation to pay them. But if they do any work during that work week, then you are obligated.
Hey, Renee, this is Mike Edwards.
Hi,
Can
Mike.
you hear me? Can you just clarify, you may have said, but can you, the distinction between furlough and obviously letting somebody go, if they're furloughed, does that imply that you're going to continue their health care, but you don't pay them an hourly rate? Is that correct?
Correct. So typically a furloughed employee is not going to be paid during that furlough because it's of a temporary nature. So there's a presumption that they are coming back. And sometimes you may know when. You could say, we are furloughing for 60 days, and we plan to open back up on this date. You could have a more open furlough that says, we're hoping to come back at this point, we don't know when. During that period, they are not paid their wages, but typically they are going to still get their benefits provided to them. So their health insurance should continue. You'll always want to check with your individual benefits provider, and also let the benefits provider know that that is your plan to furlough. But it is a way to get around having to lay off employees who you're then going to fire and rehire, because then they would lose their benefits.
And if I can, Dr. Edwards, add a clarifying question at the end there. So Renee, in the event that you choose the option to furlough, under the fairly liberal guidelines within the new Families First legislation, you would, as an employer, still be liable to cover the cost of those 10 days of sick leave and then up to 12 weeks of the FMLA work if they are furloughed and then opt into those programs. Is that Is that correct?
Potentially, yeah. I think that there is a lot of uncertainty there. If you're furloughing the employee, they can't really be on leave at the same time, right? So if you've already made a furlough decision and you're closing the office and you are temporarily shutting down, it would be very difficult for that employee to then, after the fact, take a leave. I think there's going to be some interesting considerations because one issue that we're seeing is that all of these closures are happening between now and April 2nd, right? And April 2nd is the date this would actually go into effect. So what do you do for that time frame? There has been no discussion or guidance from the feds that say that this act would be retroactive in any way. So from what we know at this point, if that employee is taking off any leave from now until then, it's not going to be covered retroactively under that act. That could change. They could give more guidance. We don't know. But if you were to shut down today and lay off or furlough, I think it would be very difficult for the employee to then, on top of that, take a leave.